And thank you so much for attending this webinar. We're very grateful to Longmores Solicitors, a chamber patron and also a sponsor of this event today. My name is Mary Sykes. I'm the External Affairs Director here at the Chamber of Commerce. And together with Longmores, we're going to deliver a really important and very relevant session all about debt recovery. Particularly during the COVID pandemic and going into recession, it is vital for businesses that they understand what the right process is to go through and ensuring that they've got the right contractual arrangements, terms and conditions, and so on. On the call today, just in terms of housekeeping and notifications, we are recording this webinar, so you will be able to view it afterwards. Also, you'll be muted during the call, but during the presentation, I should say, but we really encourage you, if you've got questions after the presentation, to either raise your hand, because I can see all of the delegates today, or use the chat function at the bottom of the screen. We will go to Q&A for about the last 10 minutes of our session here today. The first half an hour or so will be presentations by both Nat Young and Rina Sond. So we know that managing cash flow for your business is vitally important, and it's critical during the time of recession, as we mentioned, and by the impact of COVID-19. Nat Young is the senior solicitor at Longmores, specializing in insolvency and dispute resolution. Nat is going to tell us more about the steps that you can ensure, or those business colleagues you know can ensure, to make sure you get paid, and the solutions that you can put in place if payments are late. After Nat's presentation, Rina Sond. Rina is a partner specializing in company, commercial, and intellectual property. Good morning to both of you. And Rina is going to run through the different contract terms that can help your business minimize late payments. Both Nat and Rina are very well experienced with lots of professional qualifications in these areas, so you're in very good hands. And it is my pleasure now to turn the screen over with some slides and the presentation format over to Nat and then to Rina. Thank you very much to Longmores.
Thank you.
Yeah. Okay, good morning, and I thought I'd start my presentation with something that's very topical, or been topical in the last few months, which is queuing. And I think Rina's just going to turn over the slide now. Rina?
Yeah, it's slowly working.
There
It should be. There we go.
There we go. Yes, as you can see, the photograph's not quite so topical. It's actually from the Second World War. And the history behind it is that despite rationing, there were a lot of shortages of food at the time. And when shops did get new supplies, then there often wasn't enough to go round. So you'd get a long queue forming. And that's essentially the same problem you have when customers don't pay you. These people in the queue, they've got a legal right to, they've got their ration books, they've got their money, they've got a legal right to buy this food. But because the food's in short supply, not everyone's going to get what they want. And that's going to partly depend on where they are in that queue. And when you are trying to recover debts, you also have a legal right to your money. The problem is that other people have a legal right to their money as well. And some people are going to be at the front of that queue, and they may not even notice issues with getting paid. And other people are going to be at the back of the queue. They are going to have to wait a long time for payment. Maybe they're not even going to get paid at all. So when it comes to getting paid, the important thing is not to be at the back of the queue. And that's what this seminar is really about. It's making sure you're not at the back of that queue and you're not the one that's having to do without payment. And instead, you're nearer the front and you're getting paid. So I've put down a few ideas of how to avoid being at the back of the queue. And I suppose the first one really is avoiding being in the queue in the first place. Because if you avoid bad payers, then you're not going to be in a situation where there's a shortage of cash. You're going to be in a situation where you're getting paid regularly. prevention's better than cure, so obviously that's the ideal scenario. You can take some steps to help ensure that happens more often. You can vet your new customers carefully. You can stop dealing with people when you realise that they aren't good payers and they aren't paying promptly. But you do have to be realistic about how far you can take that. And sometimes, depending on your business, you may not be able to be that fussy. You might be in an industry where you can't afford to be that fussy. And even if you are very, very careful, you will still have issues. So, you know, a couple of years ago, who would have thought that Carillion wouldn't have been anything other than a great customer, you know, but then of course, they suddenly go pop and they turn into a real problem case for many, many businesses. So if you can avoid the bad payers, another possibility is that you get some sort of priority. And I'm talking here about sort of contractual priority. So it could be by having some form of charge. Obviously, if you're a bank and you've got a fixed and floating charge, you're more or less getting yourself as far to the front of the queue as you possibly can. And even if you can't get that sort of security, you might be able to get guarantees. You might be able to negotiate payment up front, payments on account of work you're doing. And Rina's going to talk about some of the contractual clauses you can use, like retention of title clauses and things like that, that just give you a sort of leg up compared to other creditors. And that won't be a solution in every case either, but it's certainly something that you'd be better off thinking about. So the next possibility is if you're going to be in the queue, as we all know from queuing in the real world, you need to start early. And the earlier you start, the nearer the front you get. And from a debt recovery point of view, that's really about getting your invoices out promptly, reminding your customers that they need to pay, chasing up promptly, and of course getting external help promptly rather than just leaving things. And if you do all that promptly, then you're always going to be a greater priority for payment than more relaxed creditors. And conversely, you know, if you aren't doing those things well, then you're going to end up by default at the back of the queue, and other people that are pushing harder are going to get paid instead of you. That's not just a case of working harder and your own processes. There are also smart solutions now, apps, particularly if you're a very small business and you don't have the staff to do that sort of chasing. This can automate the process and make it practical to get further to the front of the queue. My next suggestion is persuasion, and that sort of, as you can see, it kind of comes in two parts. There's the incentives, the sort of carrot, and then the stick, the interest, termination. And obviously, if you're in a queue, the idea is everyone has to wait their turn. But as we know from sort of wartime dramas and so on, it wasn't unheard of for shopkeepers to keep some hard to find items behind the counter for their favourite customers. So in the same way, you can sometimes get your customers to treat you better than maybe they treat other of their creditors, and improve your chance of getting paid before other people. And so in terms of the carrot, that can't be that can be underestimated very easily, because actually having a good relationship with your customers can certainly help you get paid. And I read the other day that simply adding a please or a thank you to an invoice can actually increase your chance of getting paid by more than 5%. So that's a very easy thing that we can all do that improves your chance of getting paid. But persuasion, as always, you know, has another side to it as well. And there's these ways that you can incorporate contractual clauses that put you in a stronger position if someone doesn't pay. And that in itself might incentivize them to pay you. If they know they're running up interest, if they know that they're facing some sort of penalty and they're potentially going to lose the contract and it's a valuable contract to them, then that could make all the difference. And that's particularly something I come across in an insolvency context, because if you're trying to rescue a business, then you sometimes find that they do have a couple of key contracts and they just need to keep them going. And if they're in danger of being terminated, then those creditors could end up being paid, even though it's an insolvency situation, simply because you've got to keep those contracts alive, and otherwise there isn't any business left at all. So again, in the right case, that can be a very, very important factor. And then my final point's about legal pressure, and that's something I'm going to be talking about later. For now, I'm going to pass over to Rina, who will talk about the more preventative measures, and then I'll come back to that point about legal pressure later on.
Thanks, Nat. Morning, everyone. Yes, so turning to the contract terms that can help your business get paid. First of all, as Nat mentioned, before you enter into a contract, it can be worth doing your homework, researching your prospective customers and partners, because especially in the digital age, there's nowhere to hide. If they have a history of being bad payers, or if they've not conducted themselves in the best manner in the past, then you may be able to find some information online. And if they're habitual late payers, then it might be a case that it's best to avoid them altogether, potentially. Without any contracts in place, I have to say there isn't actually any legal obligation for a client to pay you for all of your hard work. So it's really important to get a contract put into place, and even more so to get it in writing. Once you put it in writing, you have evidence of your agreement and a document to rely on in the event that payment is late or never made. So do always have a set of terms and conditions, however brief or not they may be, because it's a way of relying on this document and being clear as to what your customer is and isn't obliged to do, including obviously payment. And it just avoids you leaving yourself wide open to not being paid. Ideally, the contract should be discussed and agreed with both parties prior to the launch of a project or the start of any contract where you're providing goods or services. And it can be really important to make sure that you're quoting correctly and clearly, so that so that both parties are very clear in terms of the service and the price that is being submitted and agreed. That way, everyone knows exactly what's being provided and, more importantly, at what price. You might also want to include and agree other things at the outset, and that will be, how much obviously you're going to be paid and how, whether that's going to be sort of on day rates or by project. You should also include things like any completion date, any money that might be required up front, or any instalment payments, what also happens if the project is terminated or if things go wrong. All of these sorts of things should be set out clearly in a document so that everyone can reference and be really clear as to what's being provided, and for customers as to what they're getting. And another useful tip is actually knowing the individual in charge of billing as well, so that you can actually contact them direct if there is any invoice concern or you do need to chase for payment. So, as I say, it's important to get clear pricing and have very clear payment terms, so that those are not open to misinterpretation. A standard sort of clause in a contract would be as follows. It would be: the customer shall pay each invoice within 7 or 14 or 30 days of the date of the invoice. Those sorts of periods are fairly standard, but they can vary. And as Nat mentioned, it's important to start early. So the shorter the period between delivery of the goods and services and payment, the better, as it decreases the risk of the buyer's non-payment. And obviously, the more time the buyer has to pay, the more opportunity it has to actually spend that money elsewhere, which you want to avoid. And I mentioned about the date of the invoice rather than on receipt of the invoice, because again, this makes the payment for period clearer and again avoids arguments about when the invoice was received by the customer. That payment clause would also normally say that the payment needs to be made in full and in cleared funds, so without any deductions or setting off being permitted. And again, it's important to make sure that it's clear as to the bank account details to which payment must be transferred, or set out any other payment methods that might be agreed between you. You can also build certain payment structures into the contract as well, such as advance payment, as Nat touched upon. If you offer early payment incentives or discounts, that can entice customers to pay quickly. You could introduce payment milestones, so payments are made in instalments when certain milestones or performance has been achieved, particularly in relation to services. But with that, you should also you should always make sure that you avoid any particular milestones which involve completion of a task to a customer's satisfaction. It should be objectively assessed to make sure that it remains within your control, and again avoids a customer turning around and saying, actually, that's not been performed correctly and therefore I don't owe you this instalment. And then also invoice frequently. The faster you send out an invoice, the faster you'll get paid and be at the front of that queue that I mentioned. There can be other payment mechanisms as well that you can put into contracts. That could be things like letters of credit, which are often used by sellers who are exporting goods, or in certain circumstances, particularly say if you've got a significant amount of credit being extended, then it might be appropriate to have a charge or other security put into place, such as a guarantee. And often guarantees can be given by a parent or holding company, for example, which basically shifts the risk to a third party who acts as guarantor. Moving on to the next point, it's quite common to include interest on late payment clauses. You should make sure and make clear that if payment isn't made on time, then interest will become payable. And again, that acts as an incentive to make sure your customers do pay on time, because otherwise, obviously, they'll end up paying more money in terms of interest. It's quite common to set an interest rate of around 4% above the base rate of either the Bank of England or your own business's bank. And that should, if you don't set that out, then there is actually an implied term in business-to-business contracts where there is a Late Payments of Commercial Debts Act statute that applies, and that enforces a company it's 8% above base. And that implied term includes interest, a fixed sum, and costs for the supply of goods and services. And once that interest begins to run under the Late Payment Act, as I say, the supplier is also entitled to a fixed sum in addition to the interest on the debt, and that amount depends on the size of the debt, ranges from around £40 to £100. So it's not a massive amount of additional fixed sum costs that you can get. And also under that Act, you have an implied right to be paid the reasonable cost of recovering the debt, less the fixed sum, and that could include the costs incurred in instructing a lawyer or employing a debt collection agency. The next clause that is again quite common, especially in contracts for goods, is a retention of title clause or an RAC clause. And again, this, as Nat mentioned, this allows you to retain title or ownership of any goods until you're paid in full. And often it will be, you'll see clauses which refer to obligations on the customer to store the goods separately, to make sure that those goods are maintained in satisfactory condition and insured and are kept separate and readily identifiable as being your property until the goods are sold or returned. Ideally, there should also be a clause to ensure the customer cooperates and gives the supplier certain information related to the goods from time to time, and also possibly even reports on their ongoing financial position if they are struggling. Moving on to the next point, you can also include an alternative dispute resolution mechanism, ADR or mediation type clause, to help resolve any payment disputes. And again, this can be useful because it can avoid the relationship breaking down completely over, say, a single invoice. And it can be really useful, especially if the parties do generally wish to continue working together. And so having that mediation or an independent third party provide guidance on resolving any dispute can be quite helpful. And obviously, as Nat sort of mentioned at the start, he'll shortly cover other methods that involve undisputed sums as well in a moment. Turning to non-payment, so rather than relying on the implied term that I mentioned that's available under the Late Payments Act, it can be useful to have an express term, which is easier to enforce if it is in the contract, of course. And that can often be in the form of an indemnity, so that you're able to recover the costs of enforcing the breach of a payment term. And you know, it's perfectly reasonable to ask for those costs that you incur, and you know, they become additional unnecessary costs that you incur in pursuing them. which is obviously as a direct result of the customer breaching the terms and failing to make payments. So it can be quite common to have these sorts of clauses in the terms as well. And then finally, again, it might seem obvious, but you should also make sure you include a right for your business as a supplier to terminate the contract with immediate effect by giving written notice in circumstances where your customer commits a material breach of the payment terms, or indeed any breach at all of the terms of the contract. It's common to provide a remedy period, so giving them a little bit of time to sort it out first, and then reserving yourself the subsequent right to terminate. And tied into that point, you should have the ability, and you should normally, in practice, be able to refuse new orders from clients who have overdue accounts. And in future, you may want to think about implementing advance payment or cash on delivery policies for those chronically late payers if you do still wish to do business with them. And now I'll pass you over to Nat, who will cover the legal pressures.
Yeah, so what do I mean by legal pressure? Well, I think sometimes when people come to a debt recovery solicitor, they expect us to have some sort of magic way of getting money out of debtors. And sadly, that isn't the case. I mean, there are some methods of enforcement that don't depend on the debtor at all. And one example of that is the third-party debt order. So that's an order against someone that actually owes the debtor money, normally a bank they're in credit with. And then you can get an order requiring the bank to pay you the money in the account instead of paying it to the debtor. The debtor doesn't get any choice in that matter. The account money is already frozen by the time they find out about the application. And if everything works well, that can seem like magic. But most methods of enforcement are really about getting the debtor's attention and getting their involvement. For example, even if you use, say, High Court enforcement officers, which you might have seen on TV or something like that, to seize the debtor's goods, what you want there is not really for them to physically take possession of goods and sell them at a huge discount and try and pay you out of the proceeds. What you really want is for the debtor to realise, look, I can't carry on my business if my goods are getting taken away, and therefore you want the debtor to prioritise paying you and realising they don't really have another option. So debt recovery is really about applying different forms of pressure, making the consequences to the debtor seem unpalatable of going on not paying you, and then you can see what's the most effective. And in that respect, you really have two types of remedies, and that's why I've got a picture of the three musketeers with their rapiers. So that's one extreme. That's targeted, precise pressure that you've got a lot of control over. And then on the other hand, you've got that ugly-looking bludgeon, and that's the opposite kind of pressure. It's brutal. It may be effective, but it's not really targeted, and there's not a huge amount of control you can use with that. And so I give an example of a charging order as being a precise enforcement method. That's where you get a charge, like a mortgage, over land owned by the debtor. And a charging order, you can register it, so you get paid out of the proceeds. But once you've obtained it, you could also apply to court for the land to be sold so that you get paid. And you're in control of that process. Obviously, if the land isn't essential to the business can carry on, and you can just sell the land and get paid, and you don't mind that the debtor's carrying on in business. You aren't threatening to shut them down. That's an example of a rapier, not a bludgeon. And then on the other extreme, I think insolvency is a good example of the bludgeon in action, because in that case, you really are saying to them, look, I'm just going to shut down your business if you don't pay me. There's not a lot of control you can exercise over that, and I'll discuss that in a minute. But it can be very, very effective. You don't need to know exactly what assets they've got. They could have land, they could have goods, they could have other bank accounts that are in credit. Insolvency would affect all those assets. And if the debtor realises my business is going under unless I pay this creditor, then you'll be right at the front of the queue when it comes to payment. Another example of putting on that sort of general pressure is the one I just discussed about the High Court enforcement officers. If you've got a debtor that's a restaurant or a shop with access to the public, it can be particularly effective to send those High Court enforcement officers out there, to have a couple of heavily built gentlemen standing in your shop. Scares off the customers, debtors in that circumstance have very little option but to pay you rather than put up with that method of enforcement any longer. So again, you can get to the front of the queue that way. The danger with those sort of blunter instruments is that you don't have that control, and therefore you do get some debtors that literally bury their head in the sand. It would be rational to pay you, but they don't pay you. The pressure doesn't produce payments, so you end up shutting down their business, and you don't get any benefit yourself, because actually by then the business is shut down and there's no assets to go around, even though they could have paid you. And it's just one of those things. You don't have that level of control with those sort of processes. But what I wanted to do is just quickly run through what the actual procedure is for debt recovery. And that really is completely different if you go through the court process and then if you go through an insolvency process. So if you go through a court process, what you're looking to get is a court judgment. And a court judgment is effectively a kind of a guarantee, a seal, literally sealed document from the court telling you that you're owed a sum of money. And that judgment in itself can be very useful. First of all, if you apply for a judgment, then it means that you've got proof you're owed the money. Judgments can be set aside, but normally only shortly after they come to the debtor's attention, so they don't have long to make that application. And if you have a judgment, the court won't allow the debtor to dispute that. For example, if you then switched to insolvency proceedings, the debtor wouldn't be able to say, oh, I actually dispute this debt, without applying to set aside the judgment. And then secondly, the judgment will appear in public records. So if you're not paid within a month, it will affect the credit rating of the debtor, even if they then pay you thereafter. And if it's unsatisfied, so they still haven't paid you, they won't get any credit. And a huge number of cases where I've recovered quite difficult debts, it's happened because the debtor's gone to apply for credit and they haven't been able to get it, and therefore they've had to settle with my client who's got a judgment. And then finally, there are cases sometimes where you just don't see a viable way to enforce your debt, but you want to leave it there in the hope that the debtor in the future will be able to afford to pay. Say they've just lost their job, they're an individual, and you're hoping they get employed again. And then getting a judgment means that you don't have to worry about time running out for bringing a claim, limitation periods, and so on. That judgment in general will sit there, and you'll have enforcement options way into the future if that's necessary. So that's why judgments matter and why it's important to get that court judgment. Unfortunately, getting to the court judgment stage can be a little bit of a lengthy process. First of all, you have to send a letter before you start the court proceedings. And in the case of individuals, you've actually got to give them 30 days to respond now. And that's made court proceedings hugely less attractive than they were when you want to get quick payment. The other problem, of course, is perennial, which is a problem with court delays. So when you issue the claim, it's often a few days before it gets served on the debtor. Then they have more time to respond to the court proceedings. The other issue can be that sometimes debtors raise disputes that aren't necessarily very well-founded disputes. They're just complaints or requiring you to prove bits or picking holes in what you've said in your claim and your invoice. And in the court process, it's quite easy to blunt the pressure that you're applying by dragging out disputes and things like that. However, these disputed debts, if you follow Rina's advice, you're much more likely to be in a position where you've got clear payment terms and you're in a much stronger position to actually recover your money without issues. And for today's purposes, I'm assuming we're dealing with undefended debts. So that's the court process in a nutshell. You send the letter, you then start the court proceedings by issuing the claim form. They have a chance to respond. If they don't respond, and that frankly in my experience is most debtors don't respond, you can then get a judgment. They can do other things like respond saying they admit the sum but wanting time to pay and things like that, but we'll ignore that for now. And then you've got the insolvency process. Now, as I said, that's not mutually exclusive with court proceedings. You could get a judgment first, because with insolvency, it's very important you're working with an undisputed sum. Courts won't wind up or make bankrupt someone when there's a dispute over the amount in question. But when you've got an insolvency process, it is different when you're dealing with an individual debtor compared to when you're dealing with a corporate limited company debtor. With an individual debtor, you have to have a debt that's at least £5,000. And then what you do to start the proceedings is you prepare a statutory demand, which is a sort of formal legal document. It's a bit like a claim form, but it's not issued by the court. You just get a process server to serve it on the debtor formally, so you've got proof you've served it, and that in itself creates a bit of pressure. You've got somebody coming to your office or whatever, your shop, serving legal documents. It's not great. And that's the starting point of the bankruptcy process. When you start the bankruptcy process, then the debtor's got 21 days to either dispute the statutory demand or to make payment to you without any consequences. And then you can present a bankruptcy petition. And the bankruptcy petition, you go on to the court hearing, and if the debtor still hasn't paid, then they're actually made bankrupt. Now, with the corporate entities, it's a similar process. You can still use a statutory demand, but you don't have to. You can make an informal demand, just a letter from a solicitor saying, pay me in 7 days, and I'm going straight to issue a winding up petition. Sometimes you prefer to spread out the pressure a bit by sending the process server around with the statutory demand first, but you don't have to. And then you'll start the court process very similar way by presenting a winding up petition, and then at a hearing, if the debtor still hasn't paid, then the court will order them that they're wound up and they'll go into liquidation. Now, because the end result is liquidation or bankruptcy, and that's incompatible with the business surviving, you very often find that insolvency proceedings produce a huge amount of threat pressure, and even where the debtor doesn't necessarily interact with you at the beginning, when it moves on that far, they do change their tune, and they start being willing to pay you or to talk payment terms. The problem with it is, as I said, it's a very crude method because you do lose an element of control. In theory, insolvency isn't about debt recovery. In theory, it's about a class remedy for all the creditors. And because of that, you'll find that once you start the insolvency proceedings, for example, in corporate debtors' case, you're going to be advertising those insolvency proceedings to the world in the Gazette. Bank accounts will get frozen. Other creditors might come to light that want to take over the petition. You don't have full control over deciding whether to stop the proceedings or not. But look, these things can be worked around. And in my experience, insolvency is a very good way of getting money out of debtors, particularly when they're in that category of debtors that they can pay, they just don't want to pay. And then I'm conscious I'm running out of time, so I'm not going to go into any more detail about the actual processes involved. But I just wanted to draw attention to one thing, which is you do have to sometimes make a decision. Is the game worth the candle? Am I going to be spending too much money bringing these debt recovery proceedings, and I'm not going to actually get that money back? And that's why I said it might be a good idea to stop at, say, the judgment stage and just say, right, okay, I'll stop now. I've got my judgment. It will stay there. It will interest will accrue on that. Let's just wait for better days. There's no risk of, there's no guarantee that you'll get paid through any method. And there is also, if you've got a potential for a disputed sum, there is a risk of blowback. You start the debt recovery proceedings, then you get a 10-page letter of claim back saying that you didn't do a good job of whatever you were doing for the customer, and you start full-scale litigation. So there are things that you need to consider before you actually sort of say, right, I'm going to apply maximum pressure. This is the route I'm going to go down. And then finally, I think what I've been talking about, applying pressure to debtors, it's all about making good decisions. It's about knowing what those pressure points are. It's all right having a targeted method, but you've got to have a target. You've got to know that they've got land, or that they've got money in a bank account, and what that bank account is, what the details are. So just a few thoughts about how to get that information. The first thing is that very often clients of mine have information. They don't tell me about it at the beginning. So the first thing is just to tell your lawyer the information you've got. There's then information that you might have acquired. You can acquire through just a simple desk-based search. Look on LinkedIn, look at their webpage, and you can sometimes find out what the debtor's been doing, what their new venture is, if they're an individual, what their new employment might be. And debtors sometimes give information voluntarily. As I mentioned, during the court process, they can say, I want time to pay, I've got a new job, I just need a little bit of time. And then you can also get information from going to a third-party agency, like, some in extreme cases that might be surveillance. In less extreme cases, it might be a desk-based search, try and work out, where they've got credit and things like that. And then you can actually, in the court process, apply to get further information from a debtor, and that applies a lot of pressure in itself, because not answering the questions or answering the questions wrongly, they're answered under oath, and so it would be a contempt of court, and that puts some pressure on the debtor to give you the information, and hopefully, as a result of giving you that information, know that they've got to make payment to you. So that's all I think I've really got time for. Obviously, it's a very big topic area, so there's a lot I haven't discussed. But there will be a chance for questions. So, hopefully some questions will come in for the areas I haven't managed to touch upon.
Thank you very much to Nat and to Rina. And of course, it is question and answer time now. I'm going to open it up to the audience. And if you wouldn't mind unmuting yourselves, if you do have a question, raising your hand, then we will come to you. I do have a couple of questions as well, but I think I can see a hand from Liz Redway. Liz, if I could come to you.
Yes, thank you for that. That was a brilliant talk, by the way, really informative. I was curious about the costs involved in, and how they compare between the court route and the insolvency route, and what that might look like.
Yeah, well, that's a really good question. We do actually offer a fixed fee debt recovery scheme. So, one option is just to have a look and see what our charges look like. I'd say the main difference in costs between insolvency proceedings and court proceedings is that where you've got court proceedings, your costs are going to vary very, very much depending on the size of your debt. So if you've got a really huge debt, like £200,000, you'll pay a £10,000 fee just to start the court proceedings. It's ridiculous. It's increased hugely over recent years. But on the other hand, a lot of the other methods, particularly for smaller debts, are quite cost effective. In the case of insolvency, you're paying essentially the same amount of money regardless of the size of your debt, because in theory, you're dealing with that on behalf of the creditors as a whole. It's not just about your debt, it's about the whole body of creditors. So from that point of view, you'll find that for smaller debts, insolvency might look very expensive. For much larger debts, it can actually be the cheaper option. But of course, it's difficult because you've got to weigh up your chances of actually getting that money back again. And that's where it's really mostly, I think, the decision is not so much about price, but about what kind of debtor is this? Are they actually going to pay when push comes to shove? Am I going to get my money back from starting this process?
Thank you very much. Another question? So I've had one in that is maybe for Rina. Do you anticipate that late payments will become more prevalent in the coming months? And can you revisit or reissue payment terms after starting work with a business?
So yes, I think most businesses have probably felt the pinch a little bit with collecting payments in relation to work done over this period, and I think this probably will increase over the coming months, unfortunately. And then in terms of reissuing terms, as long as you had them in place at the start and the customer was aware of what the payment terms were, then there's absolutely no harm in sort of reiterating or resending a copy of those payment terms over to a customer when payment is due, just to sort of reinforce the position and to sort of point out to them that, these are the terms that you signed up to, and therefore, payment is now due. So yeah, as long as you've kind of provided those payment terms ahead through your terms and conditions, or where those details might be contained within your original invoices that were sent out, then there's no harm in reiterating the position, just to make sure that the customer is clear that they are required to pay on the particular times that are set out.
Brilliant, thank you very much. Oh, I've got another question I can see from Liz.
Sorry to monopolise. Just going on from the last question, actually. So if I wanted to now update my terms and conditions and my payment terms, hearing all of your wonderful information, presumably I can issue new terms and conditions with a certain amount of notice going forward. Would that be right?
Yes, you can certainly do that. I think it can be quite important to mention and set out in your existing terms and conditions about reserving the right for yourself to update and amend those from time to time. And as you mentioned, normally it's prudent to sort of say that we'll obviously give you a reasonable notice of that. Quite often you'll see that businesses will say in their terms that they're advised to check the website for any updated terms from time to time, particularly with any sort of e-commerce type businesses. But yeah, again, there's no harm in being able to update and reflect those terms from time to time. It's just making sure, though, that your customer is aware of any changes, particularly if they are quite critical to the goods or services that are being supplied. And sometimes it can be worth actually highlighting the changes as well, just so that the customer is clear. If they were going to have any issues with that, then obviously, it would be up to them to kind of raise that with you. But normally you can work on the presumption that they're accepted going forward if the customer hasn't come back with any other queries on them.
Thank you. I'm looking for any hands or any questions in chat, but I do have another question. I think we've got another time as we rapidly come to the conclusion of our time together. But a question here: would factoring invoice discounting be a good alternative to recovering debts myself? And I think that's really relevant when businesses may, particularly in the SME sector, start to panic a bit about that payment coming in. We hear about it all the time from a chamber perspective about customers not paying. And so should I discount to get it in?
Yeah, well, look, I mean, factoring and invoice discounting, I don't see them so much as ways of getting paid, as ways of securing funding. And obviously in those scenarios, particularly with factoring, where you lose control to some extent of the invoicing process normally, and someone else takes that off your hands, then they effectively have a lot of the problems that I've been discussing, and you are relieved of those problems, obviously at a price. With invoice discounting, you're generally speaking faced with the same problems that I talked about. It's just that you've got funding to kind of carry you over until your customers pay. So I think what you have to look at it is as a funding option. And if you're in an industry where, for example, you have to give 60 or 90-day terms to your customers to get paid, then obviously, that could be a really good option, because you're looking at quite a long period of time. You've got to fund your operations before you actually get the money in. And quite a lot of money can be tied up that way. Obviously, if you're in an industry where you can ask for money up front or money, on the nail, then you're much less likely to benefit from those sort of arrangements. But in the end, fundamentally, everyone has the same toolkit. So, whether it's you or a factor or whatever, everyone's facing the same problems.
Lovely. Thank you very much, Nat. We are at 11:45. I don't see any more questions. However, my feeling is there are a lot of more questions, but this is a sensitive topic that people may like to speak privately with Longmores or others. So what I would encourage you to do is take note on the backdrops for Rina and Nat. You can see that there's some social media tags in there: LinkedIn, Twitter, Facebook. Also, they've been really transparent on the Chamber website with telephone numbers, email addresses. We, of course, encourage you to link. I think some of the takeaways that I've taken as a very sort of personal human level is, please say please and thank you when you're looking to recover your invoice payments. Know the billing contact. I think that's brilliant. And sometimes you can find that out without having to ask the main kind of client that you're dealing with. And also be really clear about those payment terms from the commencement. So much of business failure or lack to to get engagement is communication. So those are clear messages that I took away. Thank you so much again to Longmores for their participation. Thank you to Nat, Charlotte, Liz, Robin, Thomas, Suki, Tanira, Lauren Lee, Georgia, Gary, Allison, John, Sue, Louise, Sonny, Joe, Michael, and Yasmin. Without you, we wouldn't have an event. We appreciate your time very much. Continue to stay safe. Please do look at the Chamber website for forthcoming events and reach out and stay connected. Have a really great rest of your day.